Before we begin, a quick and important disclaimer. This content is for educational and entertainment purposes only and does not constitute legal, financial, or professional advice. The historical laws, social customs, and fictional scenarios discussed here are intended to provide a historical perspective on the evolution of domestic relations and do not reflect current legal standards in any specific jurisdiction. Divorce laws vary significantly by state and have undergone radical transformations over the last 2 centuries. Please consult with a qualified legal professional regarding your specific circumstances. Always conduct your own due diligence before making any decisions based on historical trends or case studies presented in this series. Imagine it is 1890, and you are standing on a train platform in New York City. You are a successful professional, perhaps a lawyer or a merchant, but your personal life is a ruin. In this era, the word divorce is not just a legal term. It is a social death sentence. To even attempt to dissolve your marriage in New York, you must prove adultery in a public court, exposing your most intimate shames to a predatory press and a judgmental public. If you fail, you remain shackled. If you succeed, you might be barred from ever marrying again while your former spouse lives. This was the reality for the American man in the Gilded Age. And yet, thousands of men found a way out. They utilized a secret network of divorce colonies, exploited jurisdictional loopholes in the Dakota Territory, and redefined the American concept of personal liberty. Today, we are performing a deep dive into the masterclass of divorce help for men as portrayed through the lens of American historical fiction. We are going to look at the strategies, the psychological warfare, and the legal maneuvers that our ancestors used to navigate the most difficult transition of their lives. By examining these historical trends and case studies, we are going to solve a fundamental problem for the modern man: the feeling of being trapped by circumstance. This video will provide you with the historical context to understand that the challenges you face today are part of a long-standing American narrative of reinvention and resilience. To understand how historical fiction provides a blueprint for navigating domestic turmoil, we must first analyze the fault era of American law. In the 18th and 19th centuries, divorce was not a right. It was a rare legislative or judicial favor granted only to the innocent party. For a man in a historical novel set in the 1850s, the potential outcomes of a filing were often binary: complete vindication or total social ostracization. Historical fiction, such as the works of Edith Wharton or William Dean Howells, meticulously documents the step-by-step process men used to protect their assets and their reputations when the law was stacked against them. Consider the case study of Newland Archer in Wharton's The Age of Innocence. While he does not ultimately go through with the divorce, the text provides a granular look at the legal and social consultation process of the 1870s. A man in his position had to first consult with family elders and the tribal heads of society. This was the pre-legal stage. In historical fiction, we see that men often sought help not from a courtroom, but through a calculated series of social movements designed to make a separation seem inevitable rather than scandalous. The strategy was one of gradual withdrawal. Step 1 was the establishment of separate residences under the guise of health requirements or business travel. By studying these fictional accounts, we see a historical trend where men used physical distance to diminish the social shock of a formal filing. As we move deeper into the 19th century, the deep dive reveals the rise of the migratory divorce. This is where historical fiction meets gritty reality. Imagine the character of a businessman in a mid-century historical drama who realizes that the laws of his home state, like South Carolina, which famously allowed no divorce at all for decades, are an insurmountable wall. The help he receives comes in the form of a train ticket to Sioux Falls, South Dakota. This was the original divorce colony. Between 1890 and 1910, men would move to the frontier, establish a residency for a mere 90 days, and file in a jurisdiction that was far more lenient. The step-by-step process for these men involved more than just moving. They had to perform residency. They would open bank accounts, join local clubs, and check into specific hotels known as divorce mills. Historical fiction often depicts these men as pioneers of a different sort, men who were willing to endure the harshness of the Dakotas to secure a decree of absolute divorce. This historical trend highlights a crucial lesson for the deep dive. When one system fails you, the American tradition has always been to seek a different jurisdiction. This wasn't about getting lucky. It was a calculated legal maneuver involving specific residency requirements and the strategic selection of a venue. Furthermore, we must examine the concept of alienation of affections and criminal conversation. These are legal terms frequently found in historical fiction that modern men might find foreign, yet they represent the historical evolution of how men protected their domestic interests. In the 19th century, a man could sue his wife's lover for damages. This was often the only way a man could receive help or compensation for the breakdown of his household. Historical fiction shows us the double-edged sword of this strategy. While it provided a potential outcome of financial restitution, it also required a man to prove he had lost the services and affection of his wife, which was a humiliating public admission. In the masterclass of historical fiction, we also see the role of the private investigator, or the agent. Before the advent of modern no-fault systems, men in fiction often employed discrete third parties to gather evidence of fault. This was a meticulous, often months-long process of surveillance and documentation. The help here was technical and forensic. Novels set in the early 1900s often detail the high stakes of this evidence gathering. If a man could present an ironclad case of desertion or cruelty, he could secure the absolute divorce, which allowed for remarriage. Without it, he was stuck in a limited divorce, or a mensa tethera, which translated to from bed and board. This meant they were legally separated but still technically married, preventing either party from moving on with their lives. The psychological depth provided by these historical narratives also explores the step-by-step of reputation management. For a man in a historical context, his credit and his professional standing were inextricably linked to his marital status. Historical fiction often illustrates the financial separation that had to occur long before the legal one. Men would publish notices in local newspapers stating they would no longer be responsible for the debts incurred by their wives. This was a critical step in protecting the estate. In our deep dive, we see this as a precursor to modern asset protection. It was a public legal declaration of the end of a financial partnership. As we look at the evolution of these trends, we see a shift from the mid-19th century's rigid morality to the early 20th century's collusive divorce. This is a fascinating chapter in American historical fiction where both parties would essentially agree on a story to tell the judge to circumvent the strict laws. The help in this scenario was mutual. It involved a choreographed sequence of events where one party would allow themselves to be caught in a compromising but fabricated situation. While this was technically a fraud upon the court, historical case studies show it was a common practice for men and women who sought a civilized exit from a failed union. By analyzing these layers of historical fiction, we are not just looking at old stories. We are looking at the evolution of male agency within the American legal system. The men in these stories were navigating a world where the stakes involved their property, their children, and their very identity as citizens. This deep dive shows that the potential outcomes of a domestic crisis have always been managed through a combination of legal strategy, social positioning, and psychological fortitude. As we continue this 10-part masterclass, we will move forward in time to see how the world wars and the mid-century shift toward no fault changed the landscape forever, but the foundation remains the same: the American man's quest for a path forward when the previous one has reached its end. To understand the mid-century evolution of divorce help for men, we must step into the year 1946. Imagine you are an American man named Robert, recently returned from the battlefields of Europe. You have come home to a marriage that was forged in the haste of wartime, and you find yourself in a domestic environment that feels like a different kind of trench warfare. In 1946, the historical trends show a massive spike in divorce filings as the reality of post-war life set in. However, the legal system had not caught up with the social upheaval. If Robert lived in New York or Illinois, he was still facing a wall of restrictive statutes that required him to prove a specific, often scandalous, fault. This is where the historical fiction of the era, such as the works of Sloane Wilson or Richard Yates, provides a masterclass in the tactical maneuvers men used to find a path forward. The primary strategy for a man in Robert's position was the Reno residency. By the mid-1940s, Nevada had established itself as the divorce capital of the world by lowering its residency requirement to a mere 6 weeks. This was the ultimate loophole. In the historical fiction of the time, we see men like Robert taking a 6-week leave of absence from their corporate jobs, often under the guise of a hunting trip or a medical retreat, to establish residency in a Nevada divorce ranch. This was not a vacation. It was a calculated legal operation. The step-by-step process involved checking into a licensed ranch, engaging a local Nevada attorney, and literally counting the days until the 42nd sun rose. Case studies from this period highlight the logistical precision required. A man had to ensure his employer was on board with his absence, or he risked losing his professional standing. In historical novels, we see the character of the fixer or the confidant, usually a fellow veteran or a discreet law partner, who would handle the man's affairs back home while he was in the desert. This allowed for a potential outcome where the man could return to his home state with a legally binding decree that his home state was constitutionally required to recognize under the full faith and credit clause. However, this was a high-stakes game. If the spouse back home challenged the validity of the Nevada residency, the man could find himself in a legal limbo where he was divorced in Nevada but still legally married in New York. Historical fiction often explores the psychological warfare of the collusive agreement. Because the law required a guilty party, many men and women entered into secret contracts. Imagine Robert and his wife sitting in a dimly lit kitchen, negotiating who would take the fall. In the literature of the 1950s, we see the trend of the gentleman's agreement, where the husband would agree to be the one caught in a staged act of infidelity to spare the wife's reputation or vice versa. The help here was not coming from the court, but from a mutual desire to escape an untenable situation without total social destruction. The man would often provide the financial incentive, a generous lump sum settlement or the deed to the family home, in exchange for the wife's cooperation in the legal theater. As we move into the 1960s, the deep dive reveals a shift toward the Mexican divorce. For men who could not afford 6 weeks in Nevada, the border towns of Ciudad Juarez offered a much faster, albeit riskier, alternative. In historical fiction, the Juarez divorce is often portrayed as the desperate man's last resort. The process was startlingly brief. A man could fly down, sign a few papers, and be back in his office by Monday morning. However, the case studies of the time show that these divorces were often on shaky legal ground. This historical trend emphasizes the importance of due diligence. A man who took the shortcut often faced years of litigation later if he tried to remarry, or if his estate was contested. The 1950s and 60s also saw the rise of the separation agreement as a primary tool for men. Before a formal divorce was even possible, men in historical fiction are seen working with elite matrimonial attorneys to draft documents that settled every financial detail. This was the era of the alimony trap. Historical trends indicate that men were often terrified of being burdened with lifelong alimony payments that would prevent them from ever starting a new family. To mitigate this, men used strategic asset transfers. Step 1. Identify all liquid assets. Step 2. Negotiate a declining scale of alimony that would decrease over 5 to 10 years. Step 3. Ensure the agreement was incorporated but not merged into the final decree to protect against future modifications. In the 1960s, we begin to see the first cracks in the fault-based system that would lead to the revolutionary no-fault laws. But before that shift, men in historical fiction had to navigate the moral guardians. These were the private investigators and the neighborhood gossips who could ruin a man's case with a single photograph. A man seeking help during this period had to be a master of discretion. He had to maintain a public image of the stoic, hard-working provider, while privately dismantling his domestic life. The fictional accounts of the time, like those in Revolutionary Road, show how the pressure of this performance could lead to catastrophic outcomes. The lesson for the modern man from these historical trends is the power of emotional regulation. The men who survived the mid-century divorce system were those who could treat the dissolution of their marriage as a business transaction rather than an emotional war. Furthermore, we must look at the child custody dynamics of the era. In the mid-20th century, the tender years doctrine almost exclusively favored mothers for custody of young children. For a man in a historical novel, seeking help with his children often meant settling for the role of the Sunday father. However, a deep dive into the legal strategies of the 1960s shows that men were starting to fight for joint guardianship, a precursor to modern joint custody. This involved proving that the mother was unfit or that the father's financial stability was paramount for the children's education and future. This was a brutal uphill battle that required meticulous documentation of every interaction and expense. By studying these fictionalized versions of real-world legal struggles, we see that the American man has always been an innovator in the face of restrictive domestic laws. Whether it was the 6-week exile in Reno, the secret collusive agreements in a suburban living room, or the high-risk gamble of a Mexican decree, the goal was always the same: the restoration of personal autonomy and the preservation of a future. This part of our masterclass has focused on the era of the calculated escape. We have seen how men used every available loophole in social grace to navigate a system designed to keep them bound. But what happened when the laws themselves began to crumble? What happened when the state of California, in 1969, signed into law a bill that would change the very definition of marriage in the United States? As we transition into the next phase of our deep dive, we are going to look at the no-fault revolution of the 1970s. We will examine how this radical shift led to a new set of challenges and opportunities for men, as portrayed in the gritty, realistic fiction of the 1970s and 80s. You will learn about the rise of the divorce attorney as a weapon, and how the concept of community property turned the domestic world upside down. The next part will reveal the most controversial strategy of the 20th century, the bifurcated divorce, and why it became the secret weapon for men who needed to move on before the final gavel fell. Imagine the shock to the system when the rules of the game changed overnight, leaving thousands of men to figure out a new manual for survival in a world where fault no longer mattered. But the stakes were higher than ever. The year is 1970, and the American domestic landscape has just experienced a seismic shift that no one fully anticipated. If you are a man named David living in California, the world you woke up in is fundamentally different from the one your father inhabited. On January 1, 1970, the Family Law Act went into effect, signed by Governor Ronald Reagan, who ironically was the only United States president to have been divorced. This was the birth of the no-fault revolution. For the first time in American history, a man did not need to prove that his wife was an adulterer, a drunkard, or physically abusive to end a marriage. He simply had to cite irreconcilable differences. In the deep dive of historical fiction from this era, we see David not as a man seeking an escape from a villain, but as a man navigating a new, sterile, and often more confusing legal bureaucracy. The help he needs has shifted from finding a private investigator to finding a master of the new statutory language. Historical trends during the early 1970s show a massive surge in filings as the legal barriers collapsed. In the fiction of this period, such as Avery Corman's Kramer vs. Kramer, we see a case study of the mid-70s man who is blindsided by the new rules. Ted Kramer is the quintessential United States public character for this era. When his wife Joanna leaves, the story becomes a masterclass in the evolution of paternal roles. The historical trend was the crumbling of the tender years doctrine, which had long held that mothers were the naturally superior parents for young children. Ted's step-by-step journey involves a radical restructuring of his life. First, he must prove his domestic competency, a task that, in 1975, was often viewed with skepticism by the courts. He has to balance a high-pressure advertising career with the granular demands of child-rearing, from making French toast to managing school schedules. This reflects the potential outcomes for men of the era. They could finally fight for custody, but the price was a total reimagining of their professional identity. The legal strategy that became a lifeline for men in the 1970s was the bifurcated divorce. In historical fiction, we often see a protagonist like David pushing his attorney for this specific maneuver. To understand the depth of this strategy, you have to look at the economic instability of the 1970s, the stagflation and the energy crisis. A divorce could drag on for years as assets were appraised. Bifurcation allowed the court to grant a status-only judgment, legally dissolving the marriage while leaving the thorny issues of property division and alimony for a later date. This gave men the freedom to move forward with their lives, remarry, or invest in new ventures without the shadow of an ongoing marriage clouding their legal standing. The step-by-step detail of a bifurcated filing involved a specific motion to the court demonstrating that the delay in settling financial matters was causing undue hardship. For the man in historical fiction, this was the tactical move that prevented his life from being placed in a permanent state of suspended animation. As we move into the 1980s, the deep dive reveals a more aggressive, almost gladiatorial approach to the dissolution of marriage. This is best exemplified by the case study of The War of the Roses, a novel by Warren Adler that captured the zeitgeist of the Reagan-era yuppie divorce. The historical trend here was the shift toward equitable distribution. Unlike community property states where everything was split 50-50, equitable distribution states allowed judges to divide property based on what they deemed fair, which often led to prolonged and expensive litigation over the value of a man's career or his future earning potential. In The War of the Roses, Oliver Rose finds himself in a strategic battle for the primary residence. The fiction provides a grim warning about the mistake of abandonment. In the 1980s, if a man moved out of the family home during the proceedings, he was often seen as having constructively abandoned the property, which could lead to a permanent loss of the asset. The step-by-step advice embedded in the fiction of this era was clear. Stay in the house, maintain your presence, and do not yield an inch of physical territory until a final decree is signed. The 1980s also introduced the concept of the professional degree as marital property. This was a revolutionary and controversial development in American law. Imagine a man who worked 3 jobs to put his wife through medical school or vice versa. Courts began to view that degree as an asset that could be appraised and divided. In the literature of the time, we see men grappling with the math of their own futures. The case studies often involve a man's pension or his 401k, concepts that were becoming the primary targets in divorce court. The help for men in this era was increasingly technical. They needed forensic accountants to value their business interests and to shield non-marital assets that they brought into the union. This was the era where the prenuptial agreement began to enter the mainstream consciousness of the United States public, portrayed in fiction as the only logical defense against the equitable distribution wild card. We must also analyze the rise of the Child Support Enforcement Act of 1975 and its full integration by the mid-80s. This changed the stakes for the historical man. Failure to pay was no longer a civil matter between ex-spouses. It became a matter of state enforcement with the potential outcome of wage garnishment. In the gritty realism of 1980s fiction, we see the deadbeat dad trope emerge as a social cudgel, and men in these stories often fight back by documenting every cent of their contributions. The strategy was one of radical transparency. A man seeking to protect his reputation and his relationship with his children had to keep a meticulous paper trail of every check, every gift, and every hour spent in visitation. This was the era where the visitation schedule became a document as binding as a corporate contract. Furthermore, the 1980s saw the rise of the father's rights movement, which began to permeate American historical fiction. Characters were no longer content with being Sunday fathers. They began to utilize psychological experts to argue for the best interests of the child as a gender-neutral standard. This involved a step-by-step process of home evaluations, character witnesses, and social worker interviews. The deep dive into these narratives shows that the men who were successful were those who could demonstrate a continuous care relationship with their children. The fictional accounts highlight that the court's perception of a father's involvement was the single most important factor in a potential outcome of joint custody. By the end of the 1980s, the landscape of divorce help for men had been transformed from a moral battlefield to a sophisticated financial and psychological chess game. The man in historical fiction had evolved from a runaway seeking a Reno divorce to a sophisticated litigant managing a complex portfolio of legal maneuvers. The no-fault revolution had removed the stigma, but it had replaced it with a permanent state of negotiation. As we look toward the 1990s and the early 2000s, the world of divorce was about to be hit by a new force, the digital age. But before we get there, we must address the most significant social shift of the late 20th century, the rise of the mediated divorce. What happens when a man decides to bypass the courtroom entirely? Is it a path to peace or a trap for the unwary? In the next part of our masterclass, we are going to explore the era of the gentleman's exit in the 1990s. We will look at the rise of alternative dispute resolution and how men used mediation to protect their privacy in an increasingly public world. We will also dive into the digital discovery era, where a man's deleted emails and early internet history became the newest weapon in the divorce lawyer's arsenal. Imagine the year 1998, and your computer, once a tool for work, has just become the primary witness against you in a custody battle. How did the men of the late 90s survive the first wave of the information war? The next chapter reveals the specific strategies used to navigate the dawn of the cyber divorce. The information war of the late 1990s transformed the landscape of divorce help for men from a battle of testimonies to a battle of hard drives. Imagine you are Michael, a high-level executive at a burgeoning software company in San Jose in the year 1998. You are right in the middle of the dot-com boom. Your net worth is tied up in unvested stock options and a sprawling residence in Los Gatos. When your marriage begins to fracture, you realize that the desktop computer in your home office is no longer just a tool for productivity. It has become a Trojan horse. In this era of American historical fiction, the protagonist's greatest threat isn't a private investigator in a trench coat. It is the forensic imaging of a 500-megabyte hard drive. Historical trends during the late 90s show the emergence of electronic discovery, or e-discovery. For a man like Michael, the step-by-step process of protecting his interests began with an immediate audit of his digital footprint. In 1998, people were still operating under the illusion that hitting delete actually removed a file. The historical fiction of this period, mirroring real-world legal case studies, highlights the terrifying realization that deleted emails, early AOL Instant Messenger logs, and even browser history were recoverable through forensic mirroring. This led to a potential outcome where a man's private thoughts or business negotiations could be used as leverage in alimony negotiations, even in no-fault states like California. The strategy for the late 90s man was one of digital containment. He had to work with his attorney to issue a litigation hold on his own data, while simultaneously ensuring that his spouse's access to joint accounts was legally and ethically curtailed to prevent the unauthorized harvesting of data. Step 1 in this digital era was the preservation of evidence. If Michael were to delete files after a divorce filing was imminent, he could be accused of spoliation of evidence. This legal term, frequently explored in the legal thrillers of the late 90s, could lead to a judge issuing an adverse inference instruction. This meant the court would assume the deleted information was harmful to Michael's case. Therefore, the help for men during this period involved the hiring of early-stage digital forensic experts who could document the state of a computer at the moment of separation. This provided a baseline of truth and protected the man from false accusations of hiding assets or engaging in illicit behavior. As the calendar turned toward the year 2000, the dot-com crash added a layer of financial complexity that historical fiction often uses to drive high-stakes drama. Imagine the scenario. Michael's stock options were worth $5 million in March of 2000, but by the time his divorce reached a settlement in October, they were worth $50,000. The historical trend was the battle over the valuation date. Should the assets be valued at the date of separation or the date of the trial? For the American man in 2000, this was a life-altering mathematical problem. Men used the strategy of the Nelson formula or the time rule formula to argue that the community's interest in their stock options should be limited to the time they were actually married while working for the company. This involved a granular breakdown of vesting schedules and employment contracts, turning the divorce attorney into a quasi-accountant. This financial volatility led to the rise of alternative dispute resolution, or ADR, specifically mediation and collaborative divorce. In historical fiction, we see the 1990s man increasingly choosing the privacy of a mediator's office over the public record of a courtroom. Why? Because in the 90s, the public record was becoming searchable. For a man with a professional reputation to protect, the potential outcome of a public trial was too risky. Mediation offered a step-by-step path to a private settlement. The process involved both parties and their attorneys meeting with a neutral third party to hammer out a settlement agreement that would then be submitted to a judge for a rubber-stamped signature. This kept the digital dirty laundry out of the public eye and allowed for more creative asset distribution that a rigid judge might not permit. By 2004, a new character enters our historical deep dive. Christopher, a mid-career professional living in a Chicago suburb. Christopher is part of the first generation to deal with the social media divorce. While Facebook was still in its infancy on college campuses, sites like Friendster and MySpace were beginning to capture the social lives of adults. Historical trends show that by 2004, men were being blindsided by photos and status updates posted by friends or acquaintances. The case studies from this era illustrate the importance of the social media audit. Christopher's attorney would advise a step-by-step lockdown of all social profiles. This wasn't about hiding. It was about preventing the misinterpretation of context. A photo of Christopher at a bachelor party, taken out of context, could be used to argue he was an unfit parent, or that he was wasting marital assets on a lavish lifestyle. The help for men in the early 2000s also focused heavily on the Qualified Domestic Relations Order, or QDRO. As pensions were replaced by 401ks, the division of retirement accounts became a central pillar of divorce strategy. In the fiction of the time, we see men grappling with the reality that half of their life savings could be transferred to an ex-spouse with a single court order. The step-by-step detail of a QDRO involved hiring a specialist to draft a document that complied with both federal ERISA laws and the specific rules of the employer's plan. A single mistake in the wording could result in massive tax penalties, or the total rejection of the transfer. For the man in 2004, securing a competent QDRO specialist was as important as securing a good trial lawyer. Furthermore, we must address the gray divorce trend that started to gain momentum in the early 2000s. These were men who had been married for 20 or 30 years, and were now facing the dissolution of their partnership just as they approached retirement. In historical fiction, these stories often focus on the alimony for life fear. In many states, a long-term marriage still carried the potential outcome of permanent periodic alimony. The strategy for these men was to negotiate a buyout, a lump sum payment of assets in exchange for the termination of future support obligations. This provided the man with the certainty of a clean break and protected his future earnings and inheritance. Throughout this period, from the Silicon Valley boom to the rise of social media, the theme for men was the professionalization of the divorce process. It was no longer a personal failure. It was a corporate restructuring of the domestic unit. The men who fared best in these historical narratives were those who treated the process with the same cold, analytical rigor they applied to their careers. They used data, they used experts, and they used the shield of privacy whenever possible. They were the pioneers of the civilized divorce, even when the digital evidence suggested a much more turbulent reality. As we move into the next part of our masterclass, we are going to look at the massive disruption caused by the 2008 financial crisis and the smartphone revolution. How did the collapse of the housing market change the strategy for men who were suddenly underwater on their mortgages? And how did the introduction of the iPhone in 2007 turn every man's pocket into a 24/7 surveillance device? Imagine the year 2010, where your GPS history and your text messages are being used to track your every move during a custody dispute. The next chapter reveals the high-tech survival guide for the man navigating the most intrusive era of American history. We will dive into the short sale divorce and the rise of the apps as evidence era, where a single text message could change the course of a multi-million-dollar settlement. What happens when the house you are fighting over is worth half of what you owe on it? The answer lies in the strategic maneuvers of the Great Recession. The Great Recession of 2008 created a paradigm shift that turned the American dream into a logistical nightmare, especially for men navigating the complexities of divorce. Imagine you are Mark, a mid-level manager living in a sprawling suburb of Phoenix, Arizona, in early 2009. You bought your home at the peak of the market in 2006 for $450,000. Now, as your marriage reaches its breaking point, the appraisal comes back at $225,000. You are underwater by nearly $250,000. In this era of American historical fiction, the protagonist's struggle is not about who gets the assets, but who is stuck with the liabilities. The help for men during this period shifted from asset protection to debt mitigation. The primary strategy for a man like Mark was the short sale divorce. This was a complex, multi-step maneuver that required the cooperation of the lender, the ex-spouse, and a specialized real estate agent. The historical trend during the Great Recession saw a massive increase in these types of filings. Step 1 was the demonstration of hardship. In a divorce context, the dissolution of the marriage itself was often considered a valid hardship by banks like Wells Fargo or Bank of America. Mark had to provide a mountain of documentation, including 2 years of tax returns, recent pay stubs, and a hardship letter explaining why the mortgage could no longer be paid. Step 2 involved the strategic selection of a buyer. Because the sale price was less than the debt owed, the bank had to agree to forgive the difference. A critical component of this deep dive is the deficiency waiver. In historical case studies from the 2008 to 2012 era, many men made the mistake of completing a short sale without securing a written waiver from the lender. Without this waiver, the bank could pursue a deficiency judgment against Mark for the remaining $225,000 years after the divorce was finalized. The legal help for men in this period focused heavily on the language of the short sale approval letter. It had to explicitly state that the lender waived its right to pursue a deficiency. Furthermore, Mark had to navigate the Mortgage Forgiveness Debt Relief Act of 2007. Under this historical law, the debt forgiven by the bank was not treated as taxable income by the IRS, provided it was on a primary residence. This was a vital piece of the puzzle that prevented a massive tax bill from being the final blow to a man's financial recovery. As the housing market smoldered, the smartphone revolution was simultaneously igniting a new era of domestic surveillance. Imagine the year is 2010. Mark's pocket now contains an iPhone 4. While this device was marketed as a tool for connection, in the hands of a divorce attorney, it became a 24/7 tracking device. Historical trends show that 2010 marked the beginning of the apps as evidence era. The step-by-step detail of digital hygiene became the most important advice for men. If Mark used a shared iCloud account with his spouse, every text message, every photo, and every GPS location tag was being synced to a shared iPad at home. In the historical fiction of the early 2010s, we see the rise of the digital discovery specialist. This was a new breed of professional who could extract deleted text messages and map out a man's movements using cell tower triangulation data. For Mark, the help he needed was technical. He had to learn to disable location services and understand the permanence of the digital footprint. A single text message sent in a moment of frustration could be presented in court as evidence of a volatile temperament, potentially impacting custody outcomes. The strategy for men was one of radical self-censorship. The historical advice was simple. Never put anything in a text or email that you wouldn't want a judge to read out loud in open court. This era also saw the rise of specialized parenting apps like Our Family Wizard and Talking Parents. These tools were designed to mitigate conflict by providing a court-monitored platform for communication. For a man like Mark, these apps were a double-edged sword. On one hand, they protected him from false accusations of harassment or miscommunication. On the other hand, they required a level of meticulousness that left no room for error. Every interaction was time-stamped and archived. The step-by-step process of using these apps involved strictly sticking to logistics, pickup times, school events, and medical appointments, while avoiding any emotional or personal commentary. This was the professionalization of fatherhood. While the digital world was tightening its grip, the financial world was dealing with the collapse of the 401k. In historical case studies from 2009, many men saw their retirement accounts lose 40 to 50% of their value. This created a unique tactical opportunity in divorce negotiations. If Mark's 401k had dropped from $200,000 to $100,000, he could argue for a division based on the current depressed value, rather than the peak value. This required a forensic look at the timing of the filing. Men who filed at the bottom of the market often fared better in the long run as the market eventually recovered. The help for men in this era was often about the patience to wait for the right valuation window. Furthermore, we must examine the social media explosion of 2011 and 2012. Facebook had transitioned from a college novelty to a mainstream communication hub. Historical data indicates that by 2012, more than 80% of divorce attorneys reported that social media evidence played a role in their cases. Imagine Mark's situation. He is arguing that he cannot afford a certain level of alimony due to the recession. However, a friend tags him in a photo at an expensive charity gala or on a weekend fishing trip. This digital evidence could be used to impeach his testimony regarding his financial status. The strategy for the 2012 man was the social media blackout. Step 1. Deactivate accounts. Step 2. Request that friends do not post photos of him. Step 3. Audit all past posts for any content that could be misconstrued in a courtroom setting. By 2014, the American domestic landscape was also being shaped by the rise of the alimony reform movement. States like Florida and Massachusetts were seeing massive grassroots efforts by men to end permanent periodic alimony. This is a key theme in the historical fiction of the mid-2010s. Men who had been paying support for decades fighting for the right to retire. The help in this era was often political and advocacy-based. Men were joining organizations to lobby for laws that tied alimony duration to the length of the marriage and created clear rebuttable presumptions for the termination of support upon the payer's retirement. These historical trends highlight a shift from individual legal battles to collective systemic challenges. As we conclude this part of the deep dive, we see the American man in 2014 as a survivor of the greatest financial crisis since the Great Depression and the first generation to live under total digital transparency. He had learned to navigate underwater mortgages, deficiency judgments, and the forensic extraction of his own thoughts from his pocket. But as the economy began to stabilize and the digital world became even more integrated, a new set of social and legal questions began to emerge. What happened when the definition of marriage itself was expanded across the entire United States? How did the 2015 Supreme Court ruling in Obergefell versus Hodges impact the domestic legal landscape for all men? In the next part of our masterclass, we are going to explore the era of equality and the Gray Divorce. We will look at how the mid-2010s brought a new focus on 50-50 custody as the default starting point and how the rise of the gig economy changed the way child support was calculated. Imagine the year is 2016, and you are a man whose income fluctuates monthly because you are a consultant or an independent contractor. How do you secure a stable future for your children when the old math of the 9-to-5 world no longer applies? The next chapter reveals the specific strategies for the modern mobile American man who is redefining what it means to be a father and a provider in an era of total social flux. We will also dive into the rise of the silver splitter, men over 50 who are divorcing in record numbers, and the unique financial traps they face as they approach the finish line of their careers. The stakes are about to get even higher as we move into the era of the high-asset, late-life dissolution. The era of the silver splitter represents a critical juncture in the deep dive of American historical fiction. Imagine you are James, a 58-year-old senior consultant living in a high-rise in Chicago in the year 2016. You have spent 32 years building a career, a reputation, and a diverse portfolio of assets including a 401k, several brokerage accounts, and a vacation home in Michigan. Your children are graduated and independent. However, the domestic peace you expected to enjoy in your sunset years has evaporated. In this historical context, the stakes for a man like James are not just about a temporary disruption. They are about the potential outcomes of his entire life's work being halved just as he prepares to exit the workforce. Historical trends from 2015 to 2017 show that while divorce rates for younger couples were actually declining, the rate for those over the age of 50 had doubled since the 1990s. This created a new genre of historical fiction where the protagonist is not a young man starting over, but an established man trying to prevent a total financial collapse. The help James needs is focused on the surgical precision of asset division. A key strategy from this era is the lifestyle audit. Step 1 involves a comprehensive forensic analysis of the last 5 years of marital spending. In the fiction of this period, we see men working with specialized accountants to differentiate between the family's true standard of living and the inflated expenses that often precede a filing. This data is used to establish a realistic baseline for alimony, rather than allowing the court to rely on a snapshot of the most expensive years. The year 2015 also brought a monumental shift with the Supreme Court's ruling in Obergefell v. Hodges. While this was a victory for marriage equality, the deep dive into its legal ripples shows that it also solidified the concept of gender neutrality in family law for all men. This historical trend influenced the push for equal shared parenting. By 2016, historical fiction began to reflect a world where the 50-50 custody split was no longer a radical request, but the expected starting point. For a man in this era, the step-by-step strategy for securing this arrangement involved the creation of a parenting plan that was as detailed as a corporate merger document. This included specific provisions for the right of first refusal, which allowed the father to care for the children if the mother was unavailable for more than 4 hours, rather than relying on a babysitter. This move was designed to maximize the man's time with his children and establish his role as a primary caregiver in the eyes of the court. As we move into 2017, the deep dive reveals the impact of the gig economy on the American man's domestic legal battles. Imagine James has transitioned from a W-2 executive to a 1099 independent consultant. His income is no longer a steady, predictable stream. It fluctuates based on contracts and market demand. In historical case studies from 2016 and 2017, we see the rise of the fluctuation order. This was a legal maneuver where child support or alimony was not a fixed monthly amount, but a percentage of the man's actual income, settled quarterly. This protected the man from falling into arrears during slow business months and ensured that the support was based on real-world data rather than an optimistic projection of his earning capacity. The step-by-step detail involved providing the court with a rolling average of income over 3 to 5 years to prove the volatile nature of his professional field. A massive historical shift occurred with the passage of the Tax Cuts and Jobs Act of 2017, which took full effect for divorces finalized after December 31, 2018. For decades, the historical trend was that alimony was tax-deductible for the payer and taxable for the receiver. This created a tax subsidy that made high alimony payments more palatable for men. However, the new law eliminated this deduction. In the historical fiction of 2017 and 2018, we see men in a race against time to finalize their decrees before the deadline. The strategy for James was to settle quickly to grandfather in the old tax rules. If he missed the window, the math of his divorce would fundamentally change, shifting a significant tax burden onto his shoulders. This led to the rise of the property in lieu of alimony strategy. Instead of paying $5,000 a month in non-deductible alimony, James might negotiate to give up a larger share of the equity in the marital home, or a brokerage account to satisfy the support obligation in a tax-efficient manner. Furthermore, we must look at the double-dipping dilemma in business valuation, a frequent theme in high-asset historical fiction. If James owns a consulting firm, the court might value that business as an asset to be divided. However, if the court also uses the income from that business to calculate alimony, it is essentially counting the same money twice. The help for men in this era involved hiring valuation experts who could distinguish between enterprise goodwill, the value of the company's name and systems, and personal goodwill, the value tied specifically to James's individual skills. In many jurisdictions, personal goodwill was considered a non-marital asset that could not be divided. The step-by-step process of protecting this involved a rigorous Malkin analysis, or similar valuation methods to ring-fence the man's personal professional identity from the marital estate. Reputation management also took on a new dimension in the late 2010s. With the rise of professional networking sites and digital archives, a contentious divorce could become a permanent stain on a man's career. Historical fiction from this period portrays the use of mutual non-disparagement clauses that were wider in scope than ever before. These were no longer just about spoken words. They included specific prohibitions against posting negative information on LinkedIn, Glassdoor, or social media platforms. The strategy was to protect the man's human capital, his ability to earn a living in the future. For a man like James, a single vengeful post from an ex-spouse could derail a multi-million-dollar contract. Therefore, the legal help he sought was as much about public relations as it was about property. As we conclude this part of the deep dive, we see the American man of the late 2010s as a sophisticated navigator of a gender-neutral, but financially treacherous legal system. He has learned to balance tax law changes, business valuation nuances, and the shifting landscape of shared parenting. He is a man who understands that his past, present, and future are all being scrutinized through a lens of equality that carries high financial stakes. He has survived the era of the silver splitter by being more analytical and less emotional than those who came before him. But as the calendar turned to 2020, the world was about to be hit by a global event that would shut down the courtrooms, freeze the housing market, and trap families in their homes under unprecedented pressure. What happens when the legal system stops functioning just as your life is falling apart? How did the men of the early 2020s navigate the rise of the Zoom divorce and the pandemic parenting crisis? Imagine the year is 2020, and you are locked in a house with the person you are trying to divorce, with no trial date in sight. The next part of our masterclass reveals the high-stakes survival strategies of the most claustrophobic era in American history. We will look at the rise of the virtual trial, the force majeure clauses in domestic contracts, and the radical ways men used the lockdown to document their daily involvement with their children, turning a global crisis into a local legal advantage. The rules of the game were about to change once again, and only the most adaptable would emerge intact. The year 2020 arrived like a guillotine for the American domestic legal system, effectively freezing the gears of justice while simultaneously trapping millions of couples in a pressure cooker of proximity. Imagine you are Brian, a lead systems architect living in a suburb of Austin, Texas. In February 2020, you were preparing to file for divorce. By March 15th, you were under a stay-at-home order, locked in a 2,800 square foot house with a spouse from whom you were emotionally detached, with no clear timeline for when a courtroom would ever open again. In this specific era of American historical fiction, what we might call the era of the Great Lockdown, the help for men moved away from the courtroom and into the realm of domestic counterinsurgency and digital mastery. The protagonist in these stories is no longer the man in the courtroom. He is the man in the home office, strategically navigating the most claustrophobic environment in human history. The first and most critical strategy for a man like Brian during the pandemic was the documentation of presence. Historically, one of the greatest hurdles for working fathers was the primary caretaker presumption, where mothers were often viewed as the default parent due to their higher volume of daily interactions with the children. The lockdown flipped this script. Historical trends from 2020 show that men who were suddenly working remotely had a unique, once-in-a-century opportunity to establish themselves as primary caregivers in real time. The step-by-step detail of this strategy involved the creation of a daily pandemic log. Brian had to document every single breakfast he prepared, every Zoom school session he facilitated, and every hour he spent supervising outdoor playtime. In historical case studies from this period, we see men using this data to prove that the traditional division of labor had been permanently altered. This wasn't just about helping with homework. It was about demonstrating that Brian was the parent who understood the children's curriculum, their emotional triggers during isolation, and their daily health routines. This leads us to the rise of the Zoom divorce. As the courts slowly began to function through digital platforms, the help for men became technical. Imagine Brian's first temporary orders hearing. He isn't sitting at a mahogany table next to his attorney. He is in his guest bedroom, staring into a 1080p webcam. The historical fiction of the early 2020s highlights the digital persona as a critical legal tool. The step-by-step process of preparing for a virtual trial involved more than just knowing the law. Brian had to master lighting, audio, and background aesthetics. A man appearing in a cluttered basement or a bedroom was often perceived as less stable than a man appearing from a clean, professional-looking office space with a neutral background. Historical trends show that judges, often older and less tech-savvy themselves, were subconsciously influenced by the status signaled by a participant's digital setup. Furthermore, the strategy of the muted mic became a psychological weapon. Men learned to remain stoic and silent while their spouse or opposing counsel spoke, avoiding the angry man trope that can be exacerbated by the lag and distortion of video calls. The financial deep dive of the 2020 to 2021 era reveals a massive shift in asset valuation, known as the COVID discount. Imagine Brian's business interests. In early 2020, the economy was booming. By June, the future was an abyss of uncertainty. For the man in historical fiction, the help here was the strategic valuation snapshot. Men worked with forensic accountants to value their business or professional practices at the absolute nadir of the market. This led to a potential outcome where the marital share of the business was calculated based on depressed earnings and high-risk adjustment factors. By the time the economy recovered in 2022 and 2023, the divorce was finalized, and the man retained the full upside of the recovery. This was not about hiding assets. It was about the legal reality that an asset is worth only what a buyer would pay for it at a specific moment in time. The step-by-step maneuver involved a fair market value assessment that factored in the total cessation of global trade and local lockdowns. However, the pandemic also introduced the force majeure of domestic support. In historical case studies from 2020, we see men who were suddenly furloughed or whose commissions evaporated overnight. The strategy here was the emergency modification of support. In the fiction of the era, the protagonist has to act with lightning speed. If Brian lost his income in May but didn't file for a modification until August, he was still legally responsible for the higher support amount for those 3 months, and the court often had no power to retroactively reduce it. The help was the realization that the law does not care about your bank balance. It only cares about your filed petitions. Men had to learn to file placeholder motions to preserve their right to a reduction the moment their income was impacted. As we moved into 2021, the housing market in places like Austin, Texas, became a focal point of high-stakes drama. Brian's house, which was worth $500,000 in 2019, was suddenly being valued at $850,000 as people fled the coasts. This created the equity trap. For a man to keep the family home, he had to buy out his spouse's half of that massive equity gain. The historical trend saw the rise of the deferred sale agreement. Instead of selling the house immediately or doing an impossible buyout, men negotiated to stay in the home until the children graduated, with a specific formula for how the future sale proceeds would be divided. This preserved stability for the children and protected the man from having to take on a massive new mortgage at a time of high interest rates. The era of 2020 to 2021 also saw the weaponization of pandemic parenting protocols. Historical fiction often portrays the safety war, where one parent would accuse the other of being too lax with social distancing or masking to restrict visitation. Brian had to navigate a landscape where a trip to the grocery store could be framed as endangering the child. The strategy here was the mirror protocol. Men had to meticulously follow every CDC guideline and local health ordinance to the letter, documenting their compliance to ensure their visitation rights weren't suspended under the guise of public health. This was a new form of high-stakes compliance that required a man to be a perfect citizen to remain a present father. By the end of 2021, the information war had reached a fever pitch. With everyone trapped online, the volume of digital evidence, text messages, social media posts, and search histories exploded. The deep dive into this era shows that the most successful men were those who practiced digital hermitry. They withdrew from social media entirely, used encrypted communication for legal matters, and treated every electronic device in the house as a potential witness for the prosecution. The help in this era was the realization that in a world where everyone is watching everyone else through a screen, the only safe move is to disappear. As we conclude this part of the masterclass, we see the American man of the pandemic era as a figure who survived the most intense period of domestic scrutiny in history. He learned to be a primary parent in front of a webcam, a financial strategist in a collapsing market, and a compliant citizen in a time of fear. He turned the lockdown into a laboratory for proving his worth as a father and a provider. But as the masks came off and the world reopened in 2022, A new and perhaps even more dangerous phase began: the revenge divorce and the Great Inflation. What happens when the world speeds back up, but your support payments are tied to a 2019 economy, while your expenses are at 2024 levels? How did the men of the mid-2020s deal with the social media retribution era and the rise of AI-powered evidence gathering? Imagine the year is 2024, and your ex-spouse is using an AI algorithm to scan every photo you've ever posted to find a lifestyle mismatch. The next part of our masterclass reveals the high-tech, high-inflation survival guide for the man navigating the post-pandemic new normal. We will dive into the inflation-adjusted support battles and the terrifying rise of the digital deepfake in custody disputes. The era of pure human testimony is over. The era of the machine as witness has begun. Entering the year 2024, the American domestic legal landscape shifted from the physical claustrophobia of the pandemic to the economic volatility of the Great Inflation. Imagine you are Marcus, a senior project manager at a global logistics firm based in Seattle. It is early 2024, and the divorce you filed for in the wake of the pandemic is finally reaching the stage of final settlement. You are living in a world where the price of a gallon of milk, a kilowatt-hour of electricity, and the rent for a two-bedroom apartment have surged by double digits in just a few short years. In this era of American historical fiction, The Help for Men is no longer just about establishing a presence in the home. It is about surviving the math of a world that has become 20% more expensive, while your salary has remained largely static. The protagonist in the 2024 narrative is the economic survivalist, a man who must use data and forensic precision to prevent his future from being consumed by the rising cost of living. The first major hurdle for a man like Marcus is the battle of inflation-adjusted support. Historical trends during 2023 and 2024 show a massive spike in petitions for the modification of child support and alimony based on the Consumer Price Index or CPI. Imagine the scenario. Marcus's ex-spouse files a motion to increase support because the costs of childcare, groceries, and extracurricular activities have outpaced the original 2021 temporary orders. The help Marcus needs here is a step-by-step masterclass in economic defense. Step 1 involves the deconstruction of the household budget. Marcus must work with his legal team to perform a granular audit of actual expenses versus projected inflation. This involves a historical analysis of spending patterns to prove that while the cost of goods has risen, the actual needs of the children have not increased proportionally, or that Marcus himself is bearing the brunt of the inflation in his own separate household. Historical case studies from this period highlight the importance of the modification threshold. In many United States jurisdictions, a man's support obligation can only be changed if there is a substantial change in circumstances, often defined as a 10 to 15% shift in income or expenses. Marcus's strategy is to argue that inflation is a global phenomenon that affects both households equally, thereby neutralizing it as a ground for a lopsided increase in support. He uses the potential outcome of a cost of living adjustment or COLA clause in his final decree to ensure that any future increases are tied to objective federal data, rather than the subjective whims of a courtroom. This provides a ceiling on his liability and allows him to plan his financial future with a degree of certainty that was impossible in the chaos of the early 2020s. As Marcus navigates the economic turbulence, he is also forced to confront the terrifying rise of the digital deepfake and AI-driven evidence gathering. By late 2024 and heading into early 2025, the technology to manipulate audio and video has become accessible to the general public. Imagine a scenario where a man is presented with an audio recording of himself allegedly making threats or admitting to financial impropriety, a recording that sounds exactly like him, but which he never actually made. In this era of historical fiction, the help for men becomes forensic and technological. The strategy for Marcus is the implementation of a verified life log. This involves a step-by-step habit of using digital apps that timestamp and notarize every communication and interaction. If a fake recording is produced, Marcus can provide a chain of custody for his own location and activities at the time the recording was supposedly made. Historical trends show that by 2025, courts were beginning to require digital authentication certificates for all electronic evidence. This meant that a simple screenshot of a text message was no longer enough. The help for men involved the use of third-party software that pulls data directly from the service provider's servers, ensuring that the metadata remains intact. For Marcus, this means every text, email, and social media post is archived in a tamper-proof vault. This level of digital hygiene is the only way to survive in an era where the machine as witness can be programmed to lie. The deep dive into these cases reveals that the men who successfully defended their reputations were those who treated their personal data with the same security protocols as a high-level government contractor. Furthermore, we must examine the AI-driven lifestyle mismatch audit. By 2024, law firms were utilizing sophisticated algorithms to scrape every corner of the internet for evidence of undisclosed wealth or lifestyle inconsistencies. Imagine Marcus is arguing that his business is struggling due to the high interest rates of the mid-2020s. However, an AI bot scans his friend's social media accounts and finds a photo of Marcus on a private boat or wearing a luxury watch that was never listed in his financial disclosures. This historical trend turned every man's social circle into a potential source of incriminating evidence. The strategy for the 2024 man was the total digital sanitization. This was a step-by-step process of auditing not just his own accounts, but the accounts of his family, friends, and business associates. The help Marcus sought was from digital privacy consultants who could map out his social graph and identify any points of vulnerability before the opposing counsel's bots could find them. As we move into the current year of 2026, the landscape has evolved into the era of the hybrid parenting algorithm. The historical fiction of today portrays a world where the courts have largely accepted 50-50 custody as the default, but the logistics of the modern remote work economy have made traditional schedules obsolete. Imagine Marcus is a man who works in Seattle, but whose children live 60 miles away. In the 2026 masterclass, we see the rise of the Elastic Parenting Plan. This is a legal document that uses predictive modeling to adjust custody schedules based on work travel, school holidays, and even the mental health needs of the children. The help for Marcus is the shift from a rigid calendar to a data-driven agreement that prioritizes the quality of time over the quantity of days. This leads to the potential outcome of the parallel parenting model, a strategy frequently used in high-conflict cases in 2026. In this scenario, the help for men involves a total separation of domestic spheres. Marcus and his ex-spouse no longer communicate directly. All logistics are handled by an AI-mediated platform that filters for tone and content, stripping away the emotional toxicity and leaving only the facts of the schedule. Historical case studies show that this reduction in friction lead to a significant increase in the long-term success of joint custody arrangements. The step-by-step detail involves a court order that mandates the use of these platforms and forbids any other form of communication. For the man in 2026, this is the ultimate tool for reclaiming his peace of mind and focusing on his role as a father without the constant threat of a verbal ambush. The 2026 perspective also brings us to the high-asset blockchain audit. As more men in the tech and logistics sectors move their wealth into decentralized finance or DeFi, the divorce courts of the mid-2020s had to catch up. Imagine Marcus has assets held in various digital wallets and smart contracts. The help he needs now is the forensic blockchain analysis. This is a meticulous process of proving the origin of funds, distinguishing between premarital crypto and assets grown during the union. Historical trends show that men who were transparent and provided the public keys for their wallets fared much better than those who tried to hide them, as the transparency of the blockchain makes concealment nearly impossible for anyone without extreme technical expertise. As we conclude this part of the deep dive, we see the American man of the mid-2020s as a figure who is fundamentally defined by his relationship with data. He has survived the inflation of his expenses, the manipulation of his voice, and the surveillance of his lifestyle. He is a man who has learned that in the modern world, the truth is not what you say, but what you can prove through an immutable digital record. He has turned the tools of the information age into a shield for his future and a bridge to his children. But as the final chapters of our 10-part masterclass approach, we must address the most profound challenge of all. What happens when the battle moves beyond the borders of the United States? How does the American man navigate the international jurisdiction war when a spouse takes the children to another country or moves assets to an offshore haven that doesn't recognize U.S. decrees? The next part of our series reveals the high-stakes, global strategy of the transnational divorce. We will look at the Hague Convention, the rise of the global asset hunt, and the specific maneuvers used by men to protect their rights across 3 different continents. Imagine the year is 2026, and your children have just been taken to a country that is not a signatory to the Hague Convention. The final battle for the American man is about to go global, and the rules of the game are about to become a matter of international treaty and high-stakes diplomacy. The global battleground of the mid-2020s has transformed the traditional American divorce into a high-stakes game of international chess where the borders are porous, and the legal jurisdictions are often in direct conflict. Imagine you are Alex, a senior systems architect for a Silicon Valley firm, living in the year 2026. Your career is entirely remote, allowing you to split your time between California and a secondary residence in a Mediterranean coastal city. Your marriage has reached a breaking point, but the complexity is amplified by the fact that your spouse has just boarded a flight with your 2 children to a country where her extended family resides. This is no longer a local dispute in a Santa Clara County courtroom. This is a transnational crisis. In this era of American historical fiction, The Help for Men moves into the realm of the Hague Convention and the sophisticated maneuvers of international asset recovery. The protagonist of 2026 is the global citizen who must understand the treaties of nations as intimately as he understands the statutes of his home state. The primary legal framework that Alex must master is the Hague Convention on the Civil Aspects of International Child Abduction. This is the ultimate tool in the 2026 toolkit for a father facing the potential outcome of international parental alienation. Historical trends during the early 2020s showed a marked increase in international custody disputes as the remote work revolution allowed families to become more mobile. Step 1 for Alex is the immediate filing of a Hague petition. This is not a request for a custody determination, it is a request for a return order. The core principle of the Hague Convention is that the merits of a custody case should be decided in the child's country of habitual residence. In Alex's case, he must prove through a step-by-step documentation of school records, medical appointments, and social ties that the United States is the habitual residence of the children. The strategy for the 2026 man involves a race against the clock. Under historical case studies of the Hague Convention, if Alex waits too long, the foreign court might determine that the children have become settled in their new environment. The help Alex needs is a specialized international matrimonial attorney who understands the expedited nature of these proceedings. Step 2 involves the central authority. Every signatory nation has a designated central authority that facilitates the location and return of abducted children. Alex must work with the United States Department of State to trigger this international network. The historical data indicates that the success of a Hague petition often hinges on the speed of the initial filing. Furthermore, Alex must be prepared for the grave risk defense. In these international narratives, the taking parent often alleges that returning to the United States would expose the child to a grave risk of physical or psychological harm. Alex's counter-strategy involves the use of mirror orders, legal agreements issued by a U.S. court that ensure the safety and support of the children upon their return, effectively neutralizing the grave risk argument before the foreign judge. But what happens if the children are taken to a country that is not a signatory to the Hague Convention? This is the darkest chapter of the 2026 deep dive. Imagine the scenario where Alex's children are moved to a jurisdiction that does not recognize international treaties or U.S. court orders. In this historical context, the Help for Men shifts from treaty law to the International Parental Kidnapping Act or IPKA. This is a federal law in the United States that makes it a felony to remove a child from the U.S. with the intent to obstruct the lawful exercise of parental rights. The step-by-step detail for Alex involves working with the FBI and the Department of Justice to issue a federal warrant. This provides a different kind of leverage. While the foreign country might not return the children, the taking parent is now a federal fugitive, unable to return to the U.S. or travel to any Hague signatory nation without the risk of extradition. This is a strategy of attrition, designed to force a negotiation through the restriction of the other party's global mobility. Parallel to the battle for the children is the global asset hunt. In 2026, wealth is no longer confined to local bank branches or domestic real estate. Alex has diversified his portfolio into international brokerage accounts, offshore trusts, and decentralized finance protocols. The historical trend of the mid-2020s is the use of letters rogatory. These are formal requests from a U.S. court to a foreign court, asking for judicial assistance in obtaining evidence or performing a service. Step 1 for Alex's legal team is the identification of the foreign jurisdiction where assets might be concealed. Step 2 is the drafting of a precise, legally compliant letter rogatory that meets the specific requirements of the foreign country's civil code. Case studies from 2025 and 2026 show that the help for men in this area often involves the hiring of an international forensic accountant. This professional tracks the flow of capital across borders, using the SWIFT messaging system records and the transparency of the blockchain to create an immutable map of the marital estate. Imagine the scenario. Alex's spouse has moved a significant portion of community property into a trust in the Cook Islands or a private bank in Switzerland. The strategy for Alex is not necessarily to seize the funds in the foreign country, but to secure a shadow judgment in the U.S. This means the U.S. judge calculates the value of the offshore assets and awards Alex a corresponding larger share of the domestic assets, such as the family home or the 401k. This provides a potential outcome of financial equity without the need for a multi-year legal battle in a foreign court. The 2026 era also introduces the concept of jurisdiction shopping on a global scale. In historical fiction, we see the protagonist racing to file in the most favorable country. For example, if Alex's spouse files first in London, long known as the divorce capital of the world for its generous alimony awards, Alex could face a massive financial liability. However, if Alex files first in a jurisdiction that strictly adheres to the terms of a prenuptial agreement, he could protect his separate property. The strategy here is the lease alibi pendens maneuver, a legal principle that dictates which court should proceed when two courts in different countries have concurrent jurisdiction. The step-by-step process involves proving that the U.S. court was the first to be seized of the matter, and that it is the most convenient forum for the litigation. Furthermore, we must address the digital nomad divorce. By 2026, the historical trend of men working as permanent tourists in foreign countries has created a residency nightmare. If Alex has been living in Lisbon for 2 years while his family remained in California, which country has the right to dissolve the marriage? The help for men in this situation involves a granular analysis of the center of vital interests. Alex must document his tax filings, his voting records, and his primary social ties to maintain his U.S. residency status. Without this, he could find himself subject to the family laws of a foreign nation that may not recognize the concept of no-fault divorce or equitable distribution. Throughout this deep dive into the transnational landscape, the theme remains the professionalization of the conflict. The American man of 2026 is no longer just a litigant. He is a diplomat, a forensic investigator, and a student of international treaty law. He understands that in a world of global mobility, his rights are only as strong as his ability to enforce them across borders. He uses the Hague Convention as a shield for his children, and the letters rogatory as a sword for his finances. He has turned the complexity of the global system into a series of calculated maneuvers, ensuring that the dissolution of his marriage does not result in the dissolution of his life. As we approach the final part of our 10-part masterclass, we have covered 2 centuries of domestic evolution, from the divorce colonies of the Dakotas to the digital battlegrounds of the 2020s. But there is one final question that every man must face, regardless of the era or the jurisdiction. How do you move from the wreckage of the past to the potential of the future? In the 10th and final part, we are going to look at the masterclass of reinvention. We will explore the historical trends of post-divorce success, the rise of the second act career, and the specific strategies used by men to build a legacy that is entirely their own. What is the final, most powerful move in the American man's playbook? It isn't found in a law book or a court decree. It is found in the radical act of starting over. The conclusion of this series will reveal the ultimate strategy for turning a domestic ending into a historic beginning. The final step in our deep dive into the masterclass of American historical fiction isn't about the courtroom. It is about the morning after the final gavel falls. Imagine you are John, a 45-year-old software engineer in Austin, Texas, standing in a newly leased minimalist apartment in May 2026. The high-stakes international litigation of the previous years is over. The signatures are dry. The electronic filing notifications have ceased. For John, and for the thousands of men portrayed in American historical narratives, this is the moment of the Great Reset. This part of our masterclass focuses on the historical trends of the second act, the specific, data-driven strategies for financial, paternal, and psychological reinvention that have defined the American male experience for over 2 centuries. In historical fiction, from the stoic survivors of the Gilded Age to the tech-driven professionals of 2026, the recurring theme is that the end of a marriage is not the end of a legacy, it is the beginning of a more intentional one. The first pillar of this reinvention is the post-decree financial audit. Historical data from the mid-20th century shows that men who fail to execute the administrative follow-through of their divorce often face secondary legal crises years later. For John in 2026, the step-by-step process of the clean break begins with the Qualified Domestic Relations Order, or QDRO. We have seen in countless case studies that the mere issuance of a divorce decree does not automatically divide a 401k or a pension. John must ensure that his attorney has filed the specific QDRO paperwork with his plan administrator. Failure to do this is a historical trend that has led to men losing significant portions of their recovered wealth when they reach retirement age. Furthermore, John must perform a complete title refresh. In the historical fiction of the 1980s, we often see the trope of the ex-wife still appearing as the beneficiary on a life insurance policy decades after the split. In 2026, this involves a digital sweep, updating beneficiaries on brokerage accounts, revoking old powers of attorney, and ensuring that the title to his separate property is held in his name alone, or within a new revocable living trust. This is the tactical foundation of the new life. Once the logistics are secured, we move into the wealth reaccumulation phase. Historical trends following the 2008 financial crisis show that men who successfully navigated a divorce often experienced a period of hyperfocus on their careers. This is what we call the Phoenix strategy. In historical fiction, we see characters like Silas Lapham or modern-day equivalents who use the lack of domestic friction to scale their business interests. For John in 2026, the potential outcome of being a single filer means a different tax bracket and different investment thresholds. The strategy here involves a step-by-step reallocation of assets toward high-growth, non-marital accounts. By maximizing his contributions to tax-advantaged vehicles and utilizing the individual filing status to his advantage, John can often recover his pre-divorce net worth within 5 to 7 years. This historical case study of financial resilience is a hallmark of the American narrative, the idea that a man can be stripped of his assets and through disciplined labor and strategic investment, build a more robust estate than he had during the marriage. The deep dive into the paternal legacy of the 2020s reveals a shift from the Sunday father to the intentional presence father. In historical fiction of the 1970s, the divorced man was often a ghost in his children's lives. By 2026, the trend has shifted toward the masterclass of co-parenting. For John, the help he needs now is psychological and logistical. The step-by-step detail of this strategy involves the transition from the litigant mindset to the lead parent mindset. John uses 2026 technology, such as decentralized scheduling apps, to ensure he never misses a parent-teacher conference or a medical checkup. He documents his involvement not for a judge, but for the historical record of his children's lives. The potential outcomes of this shift are documented in social science trends. Children of involved, post-divorce fathers show higher levels of academic achievement and emotional stability. In our historical narrative, John becomes the primary emotional anchor. He realizes that his relationship with his children is a separate entity from his failed marriage, and he treats it with the same professional rigor he applies to his system's architecture. Psychological resilience in the post-divorce era is often portrayed through the lens of the Stoic Renaissance. From the characters in the novels of the early 1900s who sought solace in the rugged outdoors to the modern man in 2026, who utilizes mindfulness and high-performance coaching, the goal is the same: the mastery of the self. John's strategy for the first year of his new life is the radical removal of toxicity. Historical trends show that men who engage in post-divorce litigation through the eye for an eye philosophy often find themselves in a cycle of perpetual debt and emotional exhaustion. John chooses the path of the high road. This involves a step-by-step practice of non-reactivity. When a provocative message arrives from his ex-spouse, John applies the 24-hour rule, waiting a full day before responding, and then doing so only in a businesslike, logistics-oriented tone. This is the preservation of mental capital. By refusing to engage in the emotional theater, John retains the energy required to innovate in his career and be present for his children. The 2026 deep dive also reveals the importance of the new social graph. In historical fiction, the divorced man often becomes a pariah or a loner. The modern strategy is the intentional construction of a mentorship network. John joins professional and social organizations specifically designed for men navigating the midlife transition. These are not grievance groups. They are masterminds. They provide the case studies of men who have successfully navigated the exact same legal and financial minefields John just escaped. This historical trend of male fraternity provides a buffer against the isolation that often leads to poor decision-making or reckless financial ventures. Step 1 for John is identifying 5 men who are 5 years ahead of him in the post-divorce timeline. By studying their potential outcomes and avoiding their mistakes, John accelerates his own recovery. As we look at the historical sweep of the last 10 parts of this series, we see that the American man has evolved from a figure trapped by rigid, fault-based laws to a sophisticated operator in a complex, digital, and globalized legal system. We have seen the rise of the Reno divorce ranches, the no-fault revolution, the digital surveillance of the 2010s, and the transnational battles of 2026. The help for men has always been a combination of legal maneuver, financial discipline, and psychological fortitude. The ultimate lesson of the masterclass is that the decree is not a conclusion. It is a license for a new kind of freedom. For John, as he looks out over the Austin skyline in 2026, the future is not a scary void. It is a blank ledger. He has the tools, the data, and the historical context to write a story of success that is entirely his own. This concludes our 10-part masterclass on divorce help for men in American historical fiction. We have explored every loophole, every strategy, and every paradigm shift that has shaped the lives of men from the 1800s to the present day. You now have the full historical perspective on how the domestic world has been won, lost, and rebuilt. But as one story ends, the era of the new frontier begins. What happens when the legal system is no longer the primary arbiter of family life? How will the rise of artificial intelligence and the decentralization of the modern state change the definition of help for the next generation of American men? The era of the digital sovereign is upon us, and the strategies we've discussed are just the beginning of a much larger shift in the American domestic landscape. The masterclass is complete, but the application of these truths is a lifelong endeavor. Stand tall, execute the plan, and move forward into your own historic beginning.